Good evening, everyone. Welcome to a Be Informed session. My name is Karl Buhariwala, and I founded Be Informed to help people make good decisions. Today, we'll be looking at family law, divorce, and migration matters. We have with us Anuki and Anita from Satori Law to take us through these seminars. Before I proceed, I'd like to acknowledge the traditional owners of the lands on which we are meeting today and pay my respects to their elders, past and present. This session is being recorded and will be made available to everyone on our YouTube channel following the session. In terms of a disclaimer, I would like to make it very clear that the laws discussed today are in relation to the Australian legal framework and are based on the legal precedents and legislation set in or around July 2023. So if you do wish to rely on the information presented in this seminar, in this session, in the future, please do consider the currency of the information, and I recommend that you consult with a legal professional at that time. In terms of housekeeping matters, the session is being recorded. Secondly, one-page handouts will be sent through to your registered email address following the session, which have been kindly prepared by Anuki and Anita. And in relation to Q&A, which will follow the second seminar, please do send through your questions via the chat function directly through to me, and I will relay them through to Anuki and Anita for their response. So the first seminar will be on the process of applying for a divorce in Australia. So I'll now hand over to Anita to take us through the seminar.
Awesome, thanks, Carl. Good evening, everyone. I just wanted to say on behalf of Satori Law, thank you so much for your attendance at tonight's seminar. Hopefully the information that we give you tonight will hopefully not be applicable to your scenario, but if you do need assistance, then hopefully this information will help. The first question before getting a divorce is whether or not you are eligible for a divorce. So that's the most important step. So you need to understand the grounds for applying for a divorce. So grounds in Australia, you only need to demonstrate that the relationship has irretrievably broken down and that there's absolutely no chance of reconciliation. So you would probably have to go through a bunch of procedural things to kind of ensure that reconciliation was attempted before you go to court. And Australia also has a national family law system. So the rules for divorce applications are the same across every state. So if you live in Victoria, if you live in New South Wales, even Tasmania, it's all done by the Federal Circuit and Family Court of Australia. You may have seen in movies and TV shows that you typically would have to prove that your partner wronged you in some way, such as committing infidelity, or you can leave your partner due to mental illness or abandonment. This is not the case in Australia. Australia is a no-fault jurisdiction, so you don't have to prove that your partner did any of those things to you in order to leave them. There's no relevancy to the court as to who caused the breakdown of the relationship, so that has no relevancy whatsoever. There are a couple of prerequisites you have to satisfy in order to apply for a divorce. So the main one is that you must be separated for at least 12 months or more in order to apply for a divorce. This is defined as living apart from each other. There are certain circumstances where you may be able to apply for a divorce while living under the same roof. A couple of other requirements include that your spouse must either be an Australian citizen, live in and regard Australia as their permanent home, or ordinarily live in Australia and have done so for 12 months before filing for the divorce application. Moving on to the next slide. So there's a couple of procedural requirements and just a couple of things that the average person might not be aware of. So a couple of questions that we receive are, we haven't been married that long, can we apply for a divorce? Typically for marriages less than 2 years in length, you'll need to attend family counselling just to ensure that the relationship is definitely irretrievably broken down and you'll need to apply for a counsellor certificate. So this will prove to the court that you have tried your best to reconciliate and that sort of thing. But this will also prove that you've taken genuine steps to remedy the relationship prior to proceedings. If you or your ex-spouse don't want to attend counselling for any reason, such as domestic violence has been committed against you, or you don't feel safe, or you just don't get along, you can request permission from the court to file for divorce without a certificate. This may be granted in certain circumstances. Yes, so in order to avoid counselling, such as instances of family violence that have been committed against you, or if you can't locate your former spouse to serve documents on them, you may be eligible to apply for a waiver on that. So you wouldn't have to provide a counselling certificate. Another question that we get a lot is, can I apply for divorce without my partner's permission? They said they would refuse to sign the documents. Divorce applications in Australia can be filed jointly or by just one person to the marriage. A joint application is handy where possible if you get along and you can agree that you both want a divorce and you're happy to share the costs of the divorce application. Also, if you have children under the age of 18, you wouldn't have to go to court and no one would need to serve documents on the other party. A joint application is signed by both parties and it can be filed with the court online, and in due course it'll be looked at by a registrar of the court and the divorce will be issued. If it's a sole application and your partner doesn't agree to a divorce, you can serve the documents on your ex-partner by hand or by post. They do not need to sign any documents, they just need to be made aware of the document's existence, and they can have a chance to obtain legal representation and that sort of thing. Once documents have been served, you can upload them to the Commonwealth Courts portal for e-filing. It's a very simple and straightforward system. Typically, you can probably do that on your own. If it's a sole application for a divorce, you would then have to go to court, either self-represented or with a lawyer, to ensure that any children under the age of 18 of the marriage will be appropriately cared for. So the court will take into consideration the best interest of any children to the marriage. Is it something that you can do on your own? Yes, most people can apply for a divorce without a lawyer. You can file for a divorce application online through the Federal Circuit and Family Court of Australia website. Like I said before, if it's a joint application, there's no need for either of you to attend court. The court will consider divorce application and it will typically be granted as long as you're eligible to apply for divorce. So all of the grounds in the first slide that we discussed and all of the procedural requirements have been met. It is something that you can do on your own. However, engaging a lawyer will ensure that all of your bases are covered and all of your rights are protected. Family law proceedings can be really taxing financially and emotionally. So it's our duty as solicitors to facilitate beneficial mediation between parties in an attempt to avoid initiating court proceedings. So this can be especially difficult when children are involved. So it's best to consider legal representation for especially complex matters. How long will the process take? Am I divorced as soon as orders are made? It usually takes several months for the divorce to be finalised after initial application. The divorce is usually finalised 1 month and 1 day after final orders are made. So it's not instantaneous, there is a bit of a process, but it's a relatively quick process. Moving on to the next. So we deal with different circumstances that may arise during a divorce application. So sometimes you'll hit some speed bumps during the application. So what happens if you and your ex-partner get back together and break up again? Is it still possible to apply for a divorce? So divorce can be complex and the feelings that arise may be overwhelming and confusing for you. Should you and your partner get back together, you would only be able to do so for a maximum period of 3 months in the 12-month separation period. So one of the grounds for divorce is you need to be separated completely for a continuous period of 12 months. If you get back together for 3 months and then break up again before those 3 months, the 12-month separation period remains. If it's over 3 months and then you break up after those 3 months, over the 3 months, then your separation period will have to start again. So the court is going to consider this if you end up going ahead with a divorce application after reconnecting. Is it possible to live under the same roof and get a divorce? Yes, it is. If you live in the same house after separation, you can still apply for a divorce, just as long as you're both living separate lives. This would need to be evidenced with an affidavit. So an affidavit is a written statement swearing or affirming that a statement that you have made is true. You'll need to demonstrate a change in sleeping arrangements, ceasing all sexual activity, reduction in shared activities and family outings, making sure that your utility bills are in separate names, making sure that you're dividing your finances, and notifying your friends or family of your separation, which is a bit of an important one, just in case. Your affidavit also has to outline why you've been living together under the same roof and what steps you're taking to change these circumstances. I'm having a difficult time in my personal life during the divorce process. What can I do? The separation period prior to divorce and during the divorce process itself can be very taxing and scary and a challenging time for you personally. So there'll be questions or uncertainties relating to child support, if there are children of the marriage, financials, property and asset division. It's important to seek assistance when required by talking to loved ones or qualified mental health specialists about your circumstances. If you're legally represented, you can also talk to your lawyer about your uncertainties, and I'm sure they'll be able to assist you in those. What happens to my will? So if you have a will, any gifts you leave your ex-spouse will become invalid. Separated spouses should obtain new wills as soon as possible after a divorce finalization. So in the state of Victoria, getting divorced will make any part of your will that mentions your former husband or wife invalid. So just in case they are a beneficiary or an executor, they will cease to become those things. So it's really important to get a revised will done as soon as possible after a divorce. Separation does not affect your will the same way as divorce. So if you're separated but still married and plan to get divorced, it's important that you review your will and make any necessary changes to your future plans. So moving on to dealing with what to do when during a divorce application there are children involved and property. So the first question we get is, when can I decide what will happen with my child and property division? A divorce doesn't deal with children or property matters, so you can deal with this prior to initiating a divorce application, during or even after. So in Australia, in the Australian jurisdiction, these issues are dealt with separately. What can we do with the children? We are both still on good terms with one another. So parenting decisions can be made together or at the discretion of the court. If you and your partner remain on good terms, post-separation, you can come to an agreement amongst yourselves called a parenting plan. Now, this is not legally enforceable. It's just a written agreement between you both regarding parenting matters. But if you do want it to become legally enforceable, you can apply to the court to be granted consent orders. What happens if we don't agree about the children? If you can't come to an agreement regarding parenting, the court can make a parenting order at its discretion. They'll take into account the best interests of the child. So any decisions relating to schooling, financial support, religious upbringing, visitation, consistent routines and more will be of extreme paramount importance to the court. And remember that despite how much you and your ex-spouse are in disagreement, the court will ensure that the child has a meaningful relationship with both parents. This can also include extended families such as grandparents. How do we protect the children during the divorce process? Divorce can be a super emotional time for children of certain ages, especially if they're starting to become more aware of mum and dad's relationship. They can often feel unsettled. So just make sure children have a responsible, qualified and neutral adult to speak to about their emotions. It's also in your best interest to not belittle or degrade the other parent in front of or directly to the children. Also ensure that there's a decent amount of stability for the children and maintain family routines as much as possible before, during and after the divorce. So that concludes the kind of basic outline of applying for a divorce in Australia. Hopefully a majority of the questions that frequently come up have been answered. And yeah.
Thanks, Anita.
Thank you.
It was very clear and there's a lot of information in there. So hopefully that was very useful to those that have attended today. So Anita's details are on screen, so if you have any further queries, feel free to ask her. But of course, there will be the Q&A following Anuki's presentation. Just a reminder that this session is being recorded, so following the session, I'll be posting the recording straight to YouTube. There'll also be a one-page handout shared, which covers the matters that Anita has raised. So if you haven't captured everything in your notebook, then don't worry, there'll be a one-page handout sent out to you. So I think we can jump on to the next one. Anuki, when you're ready.
Oh, good. Thank you so much, Anita, for that. And I think that's a good segue to get into how migration law relates in family law. So just give me one moment as I just organize my slides as well. Perfect. So jumping right into it, so Anita took us through the process of how a divorce happens in Australia. Now that the question that comes up is, okay, what if I'm a temporary resident? Can I still get a divorce in Australia? If your marriage was conducted legally in your home country, the same procedure applies. So you typically need to regard Australia as a country where you see yourself living in the future. And if you have a spouse who is Australian through birth or naturalization, that is also a factor they take into account. And let's say you and your spouse are both temporary residents, you would need to prove that you all have been residing in Australia for the past 12 months. And the next question that comes up is, what documentation should I provide when I am a temporary resident in Australia? So again, it's the same documentation, your marriage certificate. Now, if you have your marriage certificate from your home country and that is in your language, you should get it translated by a certified Ngāti translator. And you provide your birth certificate and you need to prove your residency. So again, we come back to that requirement of you having to prove that you and your partner, or at least one of you all, have been living in Australia for the past 12 months. How do you prove that? Again, it's with your visa grants or something called a waiver check. A waiver check is, so it's called a visa entitlement verification document, and you can simply just go online. So when you type waiver on the internet, you click on the first link that comes up from the DHA, the Department of Home Affairs, and you put in your passport details and your visa grant, and it just shows the current visa you're on with the current conditions attached to it. So there are also scenarios where you might have gotten a visa that was granted a month ago, and you're applying for your divorce now. So if you get the waiver check for that visa that was granted a month ago, it's not sufficient for you to prove 12 months residency. So if you've been living in Australia for 4 years, you should ideally be showing all your visa grants, just to make sure that that 12-month residency period is covered and that you prove that adequately, rather than just showing what the visa that you're currently on, because that would have been granted a month or two before you lodge your divorce application. But other than that, it's not too much of a complicated procedure. It is usually the same as if you were a citizen, but you do need to prove that 12-month residency. So then just going into the next slide of the procedure requirements and things the average person may not know if you are on a visa and applying for a divorce. So what happens if my relationship ends while on a spouse visa? Now, a spouse visa has 2 stages to it. First is the temporary visa, and the second stage is where you get your permanent residency. If you and your partner decide to separate whilst you are on your stage 2, so permanent resident visa, it's not a complicated procedure. You just inform the department. but your visa isn't essentially affected. Now, if you and your partner separate whilst you're on your temporary spouse visa, so that is the stage 1 visa, you do have to notify the department. And because it's on your temporary visa, it becomes a material change in circumstances where essentially the basis for the visa is lost. There are circumstances in which you can move on to stage 2 of the spouse visa without your sponsor, as in your partner. And there are usually 3 circumstances. So if you and your partner, who is an Australian citizen, have a child together, if you have experienced family violence, or if your partner has passed away. So we'll go through those 3 grounds in detail in the next slide. So usually if you and your partner have a child together, that child is an Australian citizen. So that is why the department will consider granting you permanent residency. In the event your partner has unfortunately passed away, the department does take into consideration your partner being an Australian citizen, and they will only look into the fact if your marriage or relationship was continuing and ongoing at the time of your partner's passing. And then the second question is, which we have covered. So the third question is, my ex-partner threatened that they would cancel my visa. Is this possible? That is not possible. Your ex-partner cannot cancel your visa. It is only up to the Department of Home Affairs. What will happen is usually your partner can withdraw their sponsorship. When your partner withdraws their sponsorship, it will go through a process of natural justice. Now, what that means is the department listens, the department notices that, oh, the sponsorship application has been withdrawn. Let's ask the applicant what's happened, understand their circumstances, and then make a decision on whether to advise you of, maybe you should apply for another visa, or give you a period of 28 days to respond, or give you a couple of more days to decide if you want to stay in Australia or leave Australia. Now, that is what happens when you're on a spouse visa. There are also spouses who are considered dependents on other visas, such as a student visa, a temporary graduate visa, a work visa. The exceptions we discussed for the spouse visa, in the event that you and your partner decide to separate, the exceptions we discussed were where you can get your permanent residency if you have a child, if you've experienced family violence, and if your partner's unfortunately passed away. They do not apply in the circumstance of if you are considered a dependent on a student visa, a temporary graduate visa, or a work visa. In that circumstance, if you're a dependent on one of those visas, when you and your partner separate, you are obligated to inform the department. You usually use a form called a 1022. It's called a notification of change in circumstances form. Again, these forms are very easy to find online. They're on the department's website. So you just go on there, you go on forms and just type a notification of change in circumstances and it comes right up. You need to notify the department, and once you have notified the department, you are then given the opportunity to either apply for another visa or you would need to depart Australia. Now, in any event where your visa is refused and you are in Australia, you have a right of appeal. So that right of appeal is called a merits review appeal. A merits review appeal is where firstly you apply to the tribunal. It's called the Administrative Appeals Tribunal, where a member will essentially look at the merits of your refusal, the visa refusal, and then make a decision on if your visa should be reinstated, or what other alternative is there for you, or whether to affirm the decision of the department. So just moving on to the next slide is dealing with different circumstances that may arise during family law matters when on a spouse visa. So this is where we delve into those three exceptions, having a focus on when you experience family violence. So the first question is, someone has reported to the Department of Home Affairs that our relationship has ended. This is not true. What can I do? What evidence can I provide? This is, well, unfortunately, it is quite a common scenario where the department receives adverse information. And when they receive such information, they are obligated to act on it, whether it is true or not. So there is a procedure for that. When adverse information as such is received from the department, they contact you, who is the visa applicant, and they send a letter which is section 57 natural justice letter. And what that letter basically says is, this is what we received, this is what we've been notified about, is it true? And you are given 28 days essentially to reply to that letter. And what type of evidence can you use? So when you apply for a spouse visa, you apply on, you basically provide evidence of your financial relationship, your social relationship, household relationship, and basically giving a background about how you and your partner met. So essentially, that's what the department would want to see. Evidence of your commitment to each other and that your relationship is ongoing. So the next question is, how long will the DHA give me to respond to such claims? Again, 28 days to respond. If you do take longer to respond and you do not respond at all, you are risking your visa being cancelled or refused. If you do require more time to respond, you could always write to the department, but 28 days usually is ample time for you to just gather all that evidence and then provide a response. And then the next question is, what happens if I experience domestic violence whilst on a spouse visa? We do understand that this topic is sensitive, but it is important to know when family violence is being perpetrated and what the department really recognizes as family violence. So firstly, if you are experiencing family violence, you need to immediately notify the Department of Home Affairs. You should not, if you do not feel safe, you should you can either do it through your IMI account where your visa was lodged, or you can email the department. Do not be afraid to report instances of domestic violence out of a fear that your visa would be refused, because these circumstances are looked into by the Department of Home Affairs and they are not tolerated either. So the first thing, family violence can be perpetrated in the form of physical abuse, sexual abuse, verbal abuse, social abuse. So if you have been insulted in public and you're being constrained from, associating with your community that's here, your family, and even financial abuse is considered to be family violence, where your partner may be very controlling of your money and about you using your joint finances. So when circumstances like that happen, it is always important to notify the department. But when you do notify the department, they will, so before they assess your claim of family violence, they must be satisfied that you and your partner were in a genuine and ongoing relationship before it ceased and before the family violence is perpetrated. So again, it is demonstrating the commitment you had. So this is usually in the form of providing joint bank statements, household bills, a lease agreement, statutory declarations from your friends who can attest to the both of y'all being in a committed relationship before separation, and pictures and so on. So once once the department is then satisfied that, yep, they were in a genuine and ongoing relationship, then they will ask for evidence with regards to the family violence you have experienced. Now, this evidence comes in two forms. It's called judicial evidence and non-judicial evidence. Judicial evidence is usually court orders, intervention orders, orders against your partner that that you might have taken out against him to prevent him from committing family violence against you. Now, it is important to note that with judicial evidence, any interim orders are not considered judicial evidence. So it needs to be the final court order that you provide to the department with regards to judicial evidence. Non-judicial evidence, on the other hand, is statements from community centers that have assisted you when you have experienced family violence, police reports, hospital letters, welfare officer reports, anything of that sort. They are usually considered non-judicial evidence. And you usually, so with both these forms of evidence, you usually need to provide at least two forms of judicial evidence and non-judicial evidence. And then what happens is the department assesses all of this, and they will write to you, and with their conclusion, they will say that you can then proceed to apply for permanent residency without you having a sponsor. So that is basically a brief procedure on if you experience family violence, how you are still eligible for your permanent residency, even without a sponsor. With the other two grounds, if you have a child together who is an Australian citizen, they will grant you permanent residency. You just need to provide your child's birth certificate, and that with other documents as well, their schooling, their ties to Australia. And then if your partner has unfortunately passed away, what you would need to prove is that your relationship was genuine and ongoing at the time of his passing. And I think that concludes the migration portion and how it relates to family law. Thank you very much.
Thanks, Anuki.
Thank you, Carl.
So again, Anuki's details are on the screen. So if you have any further information, further questions for Anuki or Anita, or you would like to engage them for any help, the details are on the screen. So just a reminder, the session is being recorded. We made available to you after the session on our YouTube channel. And there's also a one-page handout which Anuki has prepared on the migration topic. So that'll be sent out to you by email. So we'll now jump into Q&A, and we'll start off with some of the questions that we've received by email ahead of the session. So maybe, Anuki, if you want to center the camera on both of you, I'll just, we'll go through them sort of sequential. So Anita, the first one that we've got is around family counselling. You mentioned that they should be seeking family counselling ahead of getting a divorce. Who should they approach? Are there sort of providers that provide this sort of service, or?
Yes, yeah, usually there are multiple providers of the service. A quick Google search will throw out a bunch of recommendations. If you do have legal representation, you can approach your lawyer and the lawyer can recommend someone. Typically just anyone accredited as a family counsellor should be able to assist in the matter.
Oh, okay, so they must be accredited. Okay, so there's a select cohort of people that are sort of in that position, and I guess they work objectively to look at both parties' views and then prepare a report that they've come to the party and have that counselling session. So great. And during the counselling session, do lawyers need to attend, or is it just a space for them?
No, lawyers don't need to attend. Typically, it would just be the parties to the divorce. It could be a bit of a private discussion, a bit emotional. So understandably, it should just be between the two parties and to air out their issues in front of a neutral party. So no, lawyers are not present.
But could they have a representative, like a support person during that session, or is that also not allowed?
Oh, it depends on the counsellor. A support person may be allowed with permission beforehand, as long as there's no threats of violence or any sort of safety issues or anything like that.
And during the discussions, during the counselling discussions, I guess it's only related to the divorce. So are property and children matters discussed during that session, or are they out of scope?
So I think with the counseling, sorry about that, it's mostly to discuss, and Anita, you can chime in at any point as well. It's mostly to discuss means to, if both parties can be together, or like give them options or methods to better their relationship, and essentially the counselor making that assessment at the end that the marriage has broken down irretrievably, and that they were advised and they were given counseling on practices that could maybe help their relationship. Properties and things like that wouldn't more so be the focus, it would be their relationship.
Right. So you wouldn't expect children to be attending that session, then it'll just be between the adults, yeah?
It would be just both the parties who are applying.
The main aim is to just assess whether reconciliation is possible between the parties. So it would just be purely focused on their relationship as a couple.
Yeah. And when the person has asked, once that certificate is prepared, how binding is it in future divorce proceedings? Like, does that actually influence the outcome, or is it just considered as part of the review of the divorce application?
Yep. So with the counseling certificate, so it's a specific form on the federal court website. So that certificate is primarily in relation to the divorce proceedings. So it's a form that you can get on the federal circuit and family court website, and that is purely with just in relation to the divorce proceedings on hand. So it wouldn't really be applicable anywhere outside the application proceedings itself, because it's just in relation to that.
Cool. That's great. And then one question that was raised was around if you applied for a divorce overseas. Okay, so say for example, I think probably more to Anuki's presentation, if you applied for a divorce in your home country and then want to get it transferred here, is there a process like that, or would you have to start a new process here in Australia to continue that? Say for example, if you migrated during the process and
no, so that would be recognized. So if you've gotten a divorce in your home country, that would be recognized here.
But if you started the process and didn't complete it, could you transfer the process across? Probably not yet.
No, you can't transfer it. So you have to apply because there are different jurisdictions of law. So you would have to initiate your proceedings from the start here. I would also, I think, add to that and say that you would need to be cognizant of, if you apply for a divorce in Australia, if that is recognized in your home country. There are certain countries where, for example, Sri Lanka, if you apply for a divorce here, it may not be recognized in your home country. So you might have to have your divorce proceedings there as well.
There might be you might have to duplicate the process in both countries, depending on the circumstances. And one question that we've got in the chat is around, can you fast track the divorce? So you mentioned, I think it's a sort of set period of time, Anita. Is there any way to sort of fast track that, or do the courts just only allow for a one time frame process?
No, as far as I know, there's no fast track to getting a divorce. Usually it's within, it's at the court's discretion, really. I guess when they have a moment to assess the divorce. There isn't really a specific time frame. They're not going to tell you, okay, in 2 weeks, we'll let you know the outcome of this application. It's at the discretion of the court. And usually the divorce is not finalized immediately once the orders are made. You have to wait about a month and 1 day, and then you can call yourself officially divorced,
Right.
celebratory or not.
Yeah.
Also, just to add to that there, Carl, so once you've submitted the divorce application, you can choose a hearing date. So again, like Anita said, it's on the availability of the court and when they have hearings that they could allocate to you. So it's just dependent on that.
And just a quick question, sorry guys, about the family counselling again. One person has asked, how many sessions would they need to attend before they get the certificate? Is it just a one-off attendance, or do they have to go to like a program of consultations to then complete the course, or is it dependent on what the counsellor chooses to do before they issue a certificate?
Oh, I guess it could be dependent on the counsellor's opinion. There isn't really, as far as I'm aware, a set number of sessions that you would have to attend. I think it's just once it reaches a certain point and the counsellor says, okay, there's no chance of reconciliation between these two parties, they'll issue a certificate. And that's just, I believe, from what I understand, that's how it would transpire.
Right.
If you have anything to add?
Yeah, it could also be a one or two sessions where you go for your counseling, and then the counselor would just need to talk to you about reconciliation methods, and then that's usually the crux of it.
Yeah. And a question on the will, because you've mentioned that the divorce is separate to the property settlement and the proceedings, right? When should you update the will? Should you do that before the property settlement or after? Because the property settlement might change the certain aspects of the estate. So the person would like to know, like, is there any strategy in doing it before or after the property settlement, or should you just do it right after the divorce, irrespective of the property settlement?
Right, yeah. So any clause in the will that includes your ex-spouse, whether it's your husband or wife, will become invalid once the divorce is processed and granted. So if you do leave property to your spouse, that clause will become invalid. So if you do want to leave it to your children or to someone else, it's best that you do affect the changes to the will as soon as possible, either before or after the divorce.
Yeah, so to those listening, it's probably worthwhile ensuring that you engage an estate's wills lawyer to make sure that you can get that sorted out as effectively as possible. So I'll jump back to the questions we received by email, and Anuki, this is sort of in your space. So you talked about the visas, yeah, and you can get the divorce processed in Australia. Is it any type of visas? If you're any type of visa that's issued in Australia, you can apply for a divorce in Australia as well? There's no limitations or anything on that?
Yes, so with the limitations, you just need to prove 12 months residency in Australia. So you would have had to show that you've been here for 12 months, and then you'll be eligible to apply for a divorce if you are a temporary resident.
Right. And what happens, I'll just jump to another question that actually was raised. If you are on a work visa here and you've been sort of traveling in and out of Australia for work, does residency timeframe get impacted by that, or?
So the residency timeframe is impacted by the duration of your visa. So let's say you're on a work visa. If that is a temporary work visa, so that's called a subclass 482, and that's been granted for 3 years. And you've been here, out of the 3 years, you've been here for 2 years, but you've been traveling, back and forth, your home country. That's fine. You've because your visa is valid for 3 years, and you've been here for 2 years. You can apply for, at least you'll be eligible. You meet that 12-month residency criteria.
Right. Another person has asked, due to some political war issues and the like, they're unable to they don't have a copy of the marriage certificate. What should they do in that instance where they don't have that sort of documentation, or it's not easy to get due to the climate in their home country?
Well, it'll be best to provide an affidavit and then explain to the court why you do not have that document. So both parties essentially would need to provide an affidavit of sort, really explaining that circumstance of not having the marriage certificate. And I think, that should suffice. Again, under the court's discretion.
Right, so you can always submit an affidavit, but might not be subject to the court's discretion and views. One person has asked in the chat, so they're on an employer, employment-sponsored visa. I'm not sure if that's the correct terminology. Can that visa be impacted by the divorce? So something in the reverse now, where the divorce impacts their work rights or something like that. Is that possible?
So let's break that down into two scenarios. So the first scenario is where you are the visa applicant. So you are the primary applicant, you hold the employer sponsor visa, you are getting a divorce, or you've gotten a divorce. Does that impact your visa? It doesn't, but you should inform immigration that yes, I do, my partner and I have gotten a divorce, but you are the primary applicant of that visa, so your visa is not affected. Now, the flip side is if you are a dependent on a work visa. What is a dependent? So like I explained earlier, dependents, they are not the primary applicants. So what happens is they have the same conditions as the primary applicants, but the crux of them having the visa is because they're a spouse of the primary applicant. If you are a dependent and you've gotten a divorce, you need to inform immigration, and you would essentially not, the basis for you to have the visa is gone. So you would then need to apply for a different visa, or really figure out if you want to continue to be in Australia or if you're going to leave. So once you inform the department, they will write to you back and say, we'll give you 21 days, 28 days to, figure out if you want to apply for another visa or, depart Australia.
Yeah. And another similar question is, so this person is asking, they're having issues. They're both on visas, and their parents are also on visas, and the children are also on visas as well. They put probably the whole family along. What happens in that sense on the child visa and the parent visa? Are those impacted, or between the spouses, domestic issues? If anything happen on the visa side?
Yeah. So again, factors like what is the visa? Is it a spouse visa? Are you the primary applicant? Are you the dependent? They all play factors into what that outcome would be. So if you are a dependent, you aren't at the best position, because you would then need to see if you're eligible for another substantive visa. Now, your child, so let's say if there is a visa where you are the primary applicant, your child is the dependent, and your partner is the dependent, and you go through it, your divorce is finalized, essentially your partner will be affected by it because he or she is a dependent on the visa. Your child would not be, because your child would still remain a dependent on your visa if you are the primary applicant. But again, like I explained before, if you are a dependent, if it's the flip side, if you're a dependent, then that would change, because then there's a material change in circumstances. The crux for you being a dependent is no longer there. And then you would then need to figure out if there is another substantive visa that you could go on.
Yeah. We just had another question come through. Interesting question. Can my migration agent help with these divorce matters, or should I sort of separate the two between my visa and my divorce?
I think it's always best to separate it, because migration and family, they're different areas of law, but it's usually good to get legal advice before you apply for a divorce, and going to a family lawyer, you'll get a thorough understanding of what the procedure is like. You get better guidance that way as well.
And final question that just come through: what happens to joint bank accounts during family violence and the subsequent divorce? If that's Anita, how are sort of joint bank accounts dealt with under that in those circumstances?
Ooh, that's actually an interesting question. Anuki might know a little bit more about this one.
So I think in circumstances like that, it would be discussion between the parties, either through the lawyers or through themselves, on what they want to do with the monies in it. It's usually assessed under the property pool, and you have disclosures on it. You go through that period of collating that property pool and seeing how much is in these joint bank accounts, coming to agreement who gets what, what's the proportion, and essentially forming an agreement is how it is dealt with.
Right. Okay. So yeah, I think as part of those property settlement discussions,
Yeah.
you'll cover off on all those bits and pieces. So great. Well, that's been a great session. I think it's been very useful for those that have attended, hopefully, and they've taken away a lot of information from that. I will share on the next screen again Anuki and Anita's details, both of Satori Law. So, and just also to flag as well that Satori Law is a returning participant on Be Informed. They previously presented earlier, late last year. So thank you again to the firm for being a participant on Being Informed. And I will just now do some closing remarks. So as a reminder, again, this session is being recorded, so it will be made available to you on our YouTube channel. And the one-page handouts will be sent through to registered participants by email. So you've got a document handy about each topic that was shared today, and you can then share those with family and friends or anyone else that needs help. In terms of the next session, we've got a session coming up on the 19th of August. Oh, sorry, 16th of August, borrowing for growth. So if you're interested to learn more about how you can borrow to help you grow your portfolio, then you might want to consider joining that session. And that probably brings us to the end of the formalities. So thank you again, Anuki and Anita, for
Thank you for having us.
Yes, thank you, Carl.
sharing that great information, and wishing everyone all the best. Bye for now.
Thank you so much,
Thank
everyone.
you. Thanks, guys.
See you guys. Bye.